Hello and welcome to our webcast for February 9, 2018. My name is Christian Lebré and this is Amy Asbrook, the director of Toujours Vivant, Not Dead Yet.
Hello.
Toujours Vivant, Not Dead Yet.
Yeah.
Okay. Also joining us, Taylor Hyatt, our policy analyst and our outreach coordinator.
Yeah.
Hi.
Hi.
Hi. Toujours Vivant, Not Dead Yet is a non-religion organization by and for people with disabilities and our allies. Our goal is to inform, unify, and give voice to disability rights opposition to assisted suicide, euthanasia, and other ending of life practices that discriminates against people with disabilities. Today's topics, we have two, like most of the time: capacity and undue influence, part 2. And the second one is Ontario's accessibility law under review. So to talk about it, Amy Asbrook will do it.
Yeah, I sure will.
And time to time I will talk a little.
Yeah. Okay, welcome to the second part of our series on capacity and undue influence. To review a couple of points from last week, we said that to be eligible for assisted suicide and euthanasia, ASE, a person must have the capacity to make the medical decision to ask for it, and their consent must be voluntary and
It's very simple and clear,
right.
which is not at all.
Right. The problem is defining those words: capacity, voluntary, and influence. The person is capable of making a medical decision if they can, one, understand information about their condition generally, and that's the understanding part of the test, apply the information to their own situation, and that's the appreciation part of the test, think through the information, weighing the benefits and drawbacks of treatment options, and come up with a decision, and that's the reasoning part. And finally, to state their choice clearly once it's made, and that's the expression part.
So to be sure, the people have to fulfill those 5 requirements to do to be able to make a decision.
Right, and those are all very much focused on mental ability. They don't take into account emotional states or social or economic factors that might be affecting the person. And so that's one of the reasons last week we talked about how that's not a very adequate statement in terms of capacity, because there are emotional things that can affect it.
Yeah.
Okay, so to be eligible for assisted suicide and euthanasia, the person must give voluntary informed consent, meaning that they have a stable, settled decision, that they're sure and not wavering, that they are free from external pressure, and that's the term used in the assisted suicide and euthanasia law, but we're going to relate that in a few minutes to the term undue influence. That they are fully informed about their illness, the purpose of the treatment, alternative options to the treatment, and risks and benefits of receiving or not receiving the treatment.
Which is not that much.
Right. And one of the things that we talked about before is that when people, when the doctors are informing them, they don't inform them about home-based personal assistance services or help getting an apartment or their home modified to be accessible, so that they're not really getting all the information they need. And since most people ask for assisted suicide for reasons related to accessibility and discrimination, that's really important information that they're not getting. Go ahead.
How much of that is the fault of the doctors, though? They're generally rather ignorant on matters of disability, accessibility, and so on.
Right, exactly. And you know, it's a lot of this is that it's not written into the law what they have to talk about. It is written that they have to mention palliative care, but they don't have to make sure the person gets palliative care. You just have to mention it. So, so much for so much for making sure the person gets what they need.
Yeah. Another thing we talked about last week is the definition of consent usually has the word treatment in it.
Yes.
And we've mentioned before that essentially death is not a treatment for a medical, social, or emotional problem that you have.
Exactly.
Very good.
Yep. That's exactly right. And finally, the last point to make about this capacity assessment is this is capacity for making the decision to die. And it's not, it's supposed to be a capacity decision to receive medical treatment, but it's not about dying. So that's essentially the point you were just making, but I needed to switch it around. Okay, today we're going to talk about some ideas that come from the area of law that deals with wills and gifts, called probate. Over the centuries, courts have established a rule that a person cannot inherit from someone that they killed unlawfully.
This law is a very old law,
Right.
So it is a very settled and very powerful law.
Yes, that's called the forfeiture rule, and it's also the plot of a ton of mystery novels. The niece murders the elderly uncle and tries to make it look like a natural death so she can inherit the uncle's fortune. And it's up to the clever detective to find the real cause of death and the person who did the murder.
We don't establish the number of those literature.
Yeah. But there are tons and tons
millions.
of they're based like that. Okay. So far, courts have said that the forfeiture rule applies in cases of assisted suicide. So if you help someone kill themselves, you can't inherit anything from them. That's mostly true, but there's an exception in New Zealand. But now that assisted suicide and euthanasia have become legal in many places, what happens if the heir helps the person kill himself? After all, Section 241 parentheses 5 of Canada's assisted suicide and euthanasia law says that no person commits an offense if they do anything at another person's explicit request for the purpose of aiding that other person to self-administer a substance that has been prescribed as part of the provision of medical assistance in dying.
So it doesn't commit any unlawful thing.
It's not an unlawful
Act.
death, so would that forfeiture law apply?
So hurrying niece or nephew may possibly inherit.
And Canada's assisted suicide and euthanasia law doesn't mention the forfeiture rule. But in New Zealand, as I said, the forfeiture rule is not applied to assisted suicide. And remember, this was supposed to be an airtight law with all kinds of safeguards and stuff. And they haven't even figured out whether this forfeiture rule applies with assisted suicide.
They doesn't even think about it now.
Right. Okay, so we come next to the idea of undue influence, weaving its way through the questions of capacity and voluntariness. This idea came out of a desire to protect people from fraud and abuse that might affect how their property is distributed after they die.
Whether it's poor people who will be victim of it,
Nothing
will really happen. But if it's really people who do that, maybe we will have some kind of.
The people who bring these cases, the amounts are couple $100,000, so it's not that much money at stake. Yeah. And it's usually the person who loses out in the will who brings challenges the will. So, okay, even though it's been around for a long time, undue influence is not well defined in the law. Courts are still coming up with new ways to explain what it is. test for it and prove it. One court said that you could tell if something is undue influence if it doesn't pass the smell test.
Yeah, if it smells bad,
Right.
because it.
If it,
Go ahead.
so if you have a hunch that something is off, that it smells fishy.
Right. Then there's probably undue influence. But again, you can't be sure of that. First of all,
Yeah. How do you?
days, and secondly, we'll talk about the things that are required for undue influence. But it's one thing that has always shocked me about the law is how cases that are almost identical can have different outcomes. And so I think that's probably the case at times. In general, undue influence means to put pressure on someone to do some act that doesn't reflect their true wishes. In other words, coercion. It comes up most often in the law related to wills, gifts, and contracts. When a will is challenged in court, the person defending the will has to assure the court that the person who wrote the will knew what it said, meant for it to give their property to the people who received it, and that the person was competent to make the will. So that's the first. Somebody comes into court, say, I challenge this will. And so the person who is basically presenting the will has to show those three things: that the person knew what they were doing, that they intended for the property to go to the people it went to, and that they were competent to make the will. Okay, then it goes back to the person who's challenging the will. And they will then have to show that there was a problem in how the will was made. They can try to show suspicious circumstances that can lead to a finding of undue influence. In the case of Vought versus Hay, the Supreme Court said to look for suspicious circumstances raised by events surrounding the preparation of the will.
That's the first of the three.
Right. Number two is events tending to call into question the capacity of the testator or the author of the will. Or three, coercion or fraud.
Is it some test do by doctors to ensure that it's existing?
No. No. And the other thing is, again, talking about how courts are having trouble defining this. This is a self-referring definition. It refers back to itself. Because if you remember, the definition of undue influence is coercion, and he's putting coercion as part three of the how to look for
Right.
undue influence. So it really gives you a sense that they're kind of screwing it up. They haven't really nailed down what they're thinking.
It smells bad.
If it smells bad, it's not, Okay. Undue influence requires three elements. Okay, here's something solid. The author of the will and the influencer are in a relationship of trust and dependence. So the person who wrote the will is in a relationship with the person who's applying the influence. And that relationship is close, a trust and dependent relationship. The second point is that the author of the will, for some reason, doesn't have the energy or strength to resist pressure from the influencer. And one court called it a sufficiently independent operating mind to withstand competing influences. So the person is capable, but they for some reason have a hard time to resist. Yeah.
It doesn't have enough strength.
Right. And the other thing is, just to let you know, I'm trying to make this understandable. And the reason I put in that part about sufficiently independent operating mind to withstand competing influences is so that you can get an idea of what the language of the law is like. So I'm trying to make it a little more understandable. Okay. The influencer the last part that's necessary is that the influencer actually uses the relationship to influence the author of the bill.
Okay, they use it as a lever.
Yeah, yeah, exactly. Okay, so undue influence goes beyond trying to convince someone or even begging. So if someone's niece,
Oh, please,
please,
I will be
Right.
very more if you don't give
Right.
me some money.
Right.
And begging is okay.
begging could do that. If someone's niece says that she will be out on the street if her uncle doesn't give her any money, oh, that's not undue influence. But if the niece threatens that she will put the uncle out on the street if he doesn't give
Go
her
out
any
of
money,
my house, you will find yourself whatever you want to do to yourself.
if you don't give me money, you're on the street.
Yeah.
That's
the
undue
undue
influence. So
So,
there's one way to remember it. That's the way.
so the influence has to push the person towards an action that's going to harm that person directly and not somebody close to them.
Yes. Yes, and in fact, the person who's applying the influence doesn't have to gain anything from it. They don't have to gain a direct or instant benefit for a court to find that undue influence is used. And courts will look at the facts of the situation, including whether the person being influenced is vulnerable or is dependent on the influencer. And other indicators that undue influence has happened include the person is socially isolated or moves to a different city where he doesn't have friends or relatives. So oftentimes, and this happens in domestic violence situations as well, the abuser or influencer isolates the person by moving them away from their friends and family and support network.
And it doesn't have to be very far away.
Right.
Just move it from his normal place to live. And because people who are old and have some handicap and they are weak,
Have a hard time getting around.
yeah, they could not move too much. They don't know how to communicate. And the people who are their friend are the same.
Right, exactly. Okay, another indication is that the person is elderly or their competence is questionable. That's another possibility. If there is a recent family conflict, and oftentimes, parents get caught between the fights of their children over inheritance and that kind of stuff, that's
No, it doesn't.
that doesn't happen. Yeah. So that's another indication.
Court are full of it.
Yeah. The person has suffered a major loss. So if their spouse died, that would be an indicator that there might be undue influence. They're at least vulnerable to undue influence.
Yes.
The person has made a new will that is different from earlier wills, especially if it leaves everything to one person, a new friend or spouse.
Yeah, 80 years old man marrying 45 years old women.
Yeah.
Sometime
That
she will inherit it all.
Right.
Yeah.
Or if some long lost relative
I don't know why.
appears out of nowhere.
I don't know why.
If the person holds back information, the author of the will holds back information or doesn't explain why they changed their will, or left out people who would usually inherit property, like their children or grandchildren. That's another indicator that there might be undue influence.
Yeah, normally patrimony is supposed to follow the line of affiliating.
Yeah. Also, the person has recently become ill or disabled, especially if the condition or treatment could affect cognitive ability or general outlook. So if the person is depressed because they're disabled, that might be an indicator that they're vulnerable to undue influence.
Very good indicator.
Yeah.
And we can't forget the influence of family or medical professionals who think that a disability is going to lead to a bad quality of life.
Right, exactly. If the person speaks another language or has a learning disability, that's another indicator of vulnerability to undue influence. If the person uses a lawyer suggested by the influencer, that's
lawyers don't do that.
That's a pretty good indicator.
If you pay them, they will.
Yeah. The person makes several wills over a short period of time. That's another clue that there might be something fishy going on. The influencer told the lawyer what to do or approved the will before it was signed.
Yeah, it happened in a case close to my family.
Close to the will is, the author of the will is depressed or lonely, which gets back to the issue of isolation, or there is evidence that the person is afraid of the influencer. So if there's treatment going on, that's another reason.
You just have to read the news, and every week there is somewhere.
Yeah. Okay, as you can see, there's a lot of overlap between suspicious circumstances, vulnerability, and the elements of undue influence.
I don't know, it smells fishy.
Yeah. As well, some of these medical condition, disability, and suffering are eligibility criteria for assisted suicide and euthanasia. So what makes you vulnerable to undue influence might make you eligible for assisted suicide.
Okay, you just push your uncle a little far, and you may end it.
Okay. This sets up a situation where the same fact could be used to prove two opposite ideas. Suffering makes a person eligible for assisted suicide and euthanasia in Canada and Europe, but it's also evident that the choice is not voluntary because of undue influence. And one judge stated that if a patient is in pain, depressed, tired, or being treated with drugs, he or she is less likely to resist the influence of others. Yet, these conditions may also add up to suffering, which would add to their eligibility for assisted suicide.
Yeah. So
I said that twice because it's a really important point. Okay. The idea of undue influence in medical decisions has so far been used mostly in situations where someone refused treatment either for religious reasons or because they were convinced that to use some alternative treatment for cancer or something. No one has challenged the assisted suicide and euthanasia laws because the person's request was subject to undue influence. And remember, again, that the Canadian law uses the term external pressure. In the Carter decision, the trial court said, and the Supreme Court agreed, that doctors would be able to assess capacity and voluntariness, including whether there was undue influence.
We have to remember that the Carter case is the beginning of all this law and all this what we talk about now.
Right. And everything in the law is supposed to flow from the Carter case, what was required. So if you remember from last week, the court told Parliament to set up a, quote, stringently limited, carefully monitored system of exceptions that raises, exceptions, end quote. That raises the question, if the courts are still trying to decide what undue influence means, how are doctors supposed to figure it out?
Yeah, but is it existing any kind of test or questionnaire or something like that?
I'll talk about that next week, but in fact, no.
Okay.
Doctors.
It's still confusion.
Yeah. Doctors don't actually have to provide evidence that the person meets the eligibility criteria. They only have to be of the opinion that it's true, according to the law.
Is that like a good faith requirement?
I'm sorry? Oh, yeah, good faith, that's a very low standard of proof.
Yeah, but most people are okay.
But
Most
do
doctors,
the
but not all.
Yeah.
That's the problem.
Okay.
but do the opinion requirements and good faith requirements work the same way?
Well, if the doctor's of the opinion, you can't really challenge somebody's opinion because it's subjective.
Mm-hmm.
So it's kind of it gives them a complete protection against any challenge.
Right. Right.
So also, the law doesn't use the term undue influence, choosing instead the term external pressure, which is never defined in the statute.
Yeah, it's another way to change world to make sure that the law is possible.
Right.
Because if they have used the normal term in the law, this law will not be able to exist.
Right. And it hasn't been used in any court cases either. So we don't know how courts will define external pressure. In using the term external pressure, maybe Parliament wanted to create an idea that combined undue influence by a person with the social and political forces that prompt people to ask for assisted suicide and euthanasia. Maybe. Factors or social and political forces like the fear of being put in a nursing home because there aren't adequate home-based services available. Forces like lack of services, adaptive equipment, and accessible transportation to enable people to do activities they enjoy. Like not having access to effective palliative care. Like having
percentage of people in Canada have access to
the Palliative Care Association says it's between 16 and 30% have access.
less than 20%.
Less than a third. Less than a third.
This is very low. So what happened to the rest of people?
Right.
Mm-hmm.
And finally, the other forces that I was thinking of is that people have to live, disabled people living below the poverty line and being bombarded with messages from medical staff, the media, and the public that their quality of life is lower and that their lives are less valuable than non-disabled people. So maybe the Parliament was thinking of that, or maybe not.
Maybe not, yeah.
Okay. Did you want to add anything, Taylor, before we move on to number 2?
Not to this.
Okay. All right. Our second topic is Ontario's accessibility law is under review. The Ontario government has appointed former Lieutenant Governor David Onley, the first person with a disability to occupy that position, to conduct the third review of the Accessibility for Ontarians with Disabilities Act, also known as the AODA. The Act requires review of its effectiveness every 3 years. The AODA is designed to remove barriers by creating standards for government departments and businesses in a few major areas: requirements for customer service, information and communications, employment, transportation, and the design of public spaces are currently in place. Accessibility standards for healthcare and education, 2 crucial domains in the lives of people with disabilities, are still in progress. So that law has been in effect since what, 2006?
Yeah, I started high school the year it came out.
Okay, so they've been working on it for more than 10 years, and they've got some parts that they've made some progress on, but some parts that they haven't. Some pretty important parts, like healthcare.
Yeah.
Yeah, if you're not healthy, you're not going to benefit from anything else that it offers you.
Exactly. Mr. Onley is responsible for, quote, consulting with the public and analyzing accessibility progress made in other jurisdictions, unquote. His review will be completed by the end of this year. We expect that when he compares Ontario's law with its equivalents across Canada, he'll find plenty of areas where the province needs to improve. Although Mr. Onley has also been asked to consider the evolution of the law and its goals for an accessible Ontario by 2025 and beyond.
By 2025.
Right, so they have 7 years to get their act together.
And they doesn't yet meet the criteria of the second evaluation.
Right.
Mm-hmm. How are they going to combine everything to make one definition of an accessible Ontario? How are they measuring that? And how's it going to work when it's taking so long for the most basic standards to be written up and implemented?
Yeah, exactly. And there's, although he has to do this, there is still a lot of work to be done. Let's see, not the guy's name, but only some of the recommendations from the second review have been implemented, including the appointment of a minister responsible for accessibility, Tracy McCharles. The last evaluation was done by Mayo Moran, Provost and Vice Chancellor of Trinity College at the University of Toronto in 2015. So to sum it all up, although the review is much needed, we're not sure how much it will accomplish.
Probably very. And when they will reach close to 2025, they will try to do everything at the same time and do nothing.
Right. Yeah. So they'll just come up with a big report. Gee, we didn't make the deadline, but oh well.
Yeah.
And they will change the date for 2030.
Yeah. And everything that will be done at the end is probably going to be done halfway. Wonderful.
Exactly. Half fast. Not slow, not fast, but half fast.
Wow.
Okay. All right.
Like signaling device in a ship, you know.
Yeah.
Full ahead, stop.
Yeah.
Oops, oops.
Okay. So if you have any questions on the topics that we discussed here, you can go to our Facebook page at facebook.com/toujours-vivant, not dead yet. You can visit our website at tvndy.ca. You can email us at info@tv-ndy.ca, or you can follow us on Twitter @TVNDY. Thanks to Taylor for helping out and to Christian as well.
Thank you.
Thanks you for being there, and we will see you next time.
Take care. Bye.
See you in a week.